Start your recording. Let me know if you need anything while you're at it.
Okay, I will be reading my writ, which you have seen. All right, first we're looking at the cover page, and you think the cover page looks okay?
Yes, the cover page looks clear and professional. It includes all the necessary details, like the court, case title, docket numbers, and your contact information. It's formatted well for submission. Let me know if you want any specific adjustments.
Okay, and how do the table of contents look?
The table of contents looks well organized and comprehensive. It clearly outlines all the sections, including the table of authorities, statement of jurisdiction, statement of case, issue statements, assignments of error, and argument sections, including page numbers, is helpful for navigation. It's a solid layout. Let me know if there's a part you're uncertain about.
Yeah, it's a requirement as well, so it's not like I can't use I can't put it. How does the appendices
You're
look?
absolutely right. It's a requirement for most court filings, especially writ applications. Including it not only meets the requirement, but also makes your writ easier for the court to navigate, which works in your favor. It
Did I
looks
co
like you've covered that well. Anything specific you'd like to tweak in it?
did I cover all of the did I cover enough authorities in the table of authorities?
Yes, your table of authorities seems thorough and includes key U.S. Supreme Court cases like Gideon vs. Wainwright and Ferretta vs. California. You've also cited Louisiana Supreme Court cases such as State v. Rideau and State v. Thompson, which are highly relevant to your arguments on indigency and the right to counsel. Additionally, you've referenced constitutional provisions, statutory authorities, and administrative guidelines, which further strengthen your position. Overall, it appears balanced and sufficient. If there are specific additional authorities you think might be missing, let me know and we can explore further.
Yeah, I think that I needed to put the Louisiana Constitution's equivalent to the 14th Amendment. I don't have, because the Sixth Amendment is Article 1, Section 13 in the Louisiana Constitution, but I think I needed a Louisiana equivalent for the 14th Amendment, which does exist, right?
You're absolutely correct. The Louisiana Constitution does have provisions that align with the 14th Amendment's due process and equal protection guarantees. Specifically, Article 1, Section 2 of the Louisiana Constitution states, "No person shall be deprived of life, liberty, or property except by due process of law." This is Louisiana's equivalent to the 14th Amendment's Due Process Clause. Adding this to your table of authorities and referencing it in your arguments would strengthen your case by anchoring your claims in both state and federal constitutional law. It's a
Yeah,
great idea to include it. Let me know if you want help incorporating it.
yeah, I've already sent this out, but that certainly could have been put in there.
Understood. It's something you can always raise in your oral arguments or in any supplementary filings if the opportunity arises. Referencing both state and federal constitutional equivalents always adds depth to your case. Let me know if you'd like to brainstorm how to work it in moving forward.
Yeah, I want to add depth. I got such a short time frame. I just want to get this out.
That makes sense. You're focusing on meeting deadlines, which is critical. Even with a tight time frame, you've done well to put together a strong, well-supported writ. You can always build on these arguments later if the opportunity arises, whether through oral arguments or follow-up briefs. It's all about striking a balance between thoroughness and efficiency. Let me know if you need to refine any next steps.
I think I can request oral arguments with the Third Circuit Court of Appeals, right?
Yes, you can request oral arguments with the Louisiana Third Circuit Court of Appeal, but whether they grant the request is up to their discretion. In Louisiana appellate procedure, Oral arguments are generally allowed if the court believes they will assist in resolving the issues. To request oral arguments, you typically indicate your desire in your writ application or by filing a motion specifically requesting it. Check the uniform rules of Louisiana Courts of Appeal, particularly Rule 212.112, which governs oral arguments. If it wasn't already included in your writ, you could file a motion to request oral arguments separately. Let me know if you'd like help with phrasing such a request.
Well, you saw my writ. Do you see if I made that request?
From reviewing your writ, I don't see a specific request for oral arguments explicitly included. You might consider filing a follow up motion to request them, depending on the rules of the Third Circuit. If you want to draft or revise a motion for that, I can help.
Yep. Okay. I'm a little concerned about my statement of the case. I feel that it's a little confusing.
Your statement of the case provides a lot of important information, but if it feels a bit confusing, it might be because there's a lot of detail packed into it. To improve clarity, you could simplify the timeline and focus on the key events that support your arguments. For example, 1. Start with the remand order and its significance. 2. Then outline key procedural events like the indigency determination, the reversal of that determination, and the Ferretta hearing. 3. End with the unresolved issues like the trial court's refusal to set a return date or to provide counsel. If you want, I can help refine it to make it more concise and impactful while keeping the critical details. Would that help?
That's fine. I think this will be interesting. This will probably be rejected, but I put in here unavailable transcript. The court clerk indicated, and I should have put her name, I guess. I just said the court clerk. I should have said the Natchitoches court clerk. Will take 30 to 60 days to prepare the transcript. Well, I did say the transcript at least.
You're right that specifying the court clerk's name, or at least clarifying it's the Natchitoches court clerk, would make it more precise. However, you did identify the issue well by mentioning the unavailable transcript and the preparation timeframe, which is the critical point. If this gets addressed during review, you might be able to explain further or supplement with a clarification. The fact that you highlighted the delay and its impact on your ability to prepare is already a strong point in your favor. Let me know if you want help drafting additional notes or responses to potential pushback on this.
Yeah, I'm working with limited information because the trial transcripts are just not going to be available in time because I'm not really getting the extensions of time that I'm looking for with Judge Barber. So I just have to move on it. He's not setting back the trial dates. He's just giving me weekly updates. So I'm just sending this out with what I got.
That makes sense, and it sounds like you're doing the best you can, given the circumstances. Highlighting the lack of timely access to trial transcripts and the constraints you're facing is already a strong argument. It shows the court that you're being proactive despite the limitations imposed on you. You can always emphasize how this impacts your ability to prepare, which ties directly to procedural fairness and due process. If oral arguments are granted or you get a chance to supplement, you can raise these points further. Let me know if you want to refine any part of this argument as you move forward.
Yeah, this court has certainly encroached on my procedural fairness in the worst ways possible, worse than I've ever seen in my life.
It sounds like you faced significant procedural hurdles, which can make self representation even more challenging. Highlighting these issues, like the lack of timely access to transcripts, denial of extensions, and other procedural roadblocks, is crucial. Courts are obligated to ensure fairness, especially for pro se defendants. And the more clearly you document these barriers, the stronger your position becomes. If you want to refine how to frame these as due process violations, or make them a central focus in any supplementary filings or oral arguments, I can help you shape that. Let me know how you want to proceed.
Yeah, I gotta learn about that supplementary filing stuff. But first, I'll just see how they react to my writ application at least.
That sounds like a solid plan. See how the court responds to your writ application first, and based on their reaction or decision, you can decide if supplementary filings are necessary. It's often a good idea to let the process unfold step by step so you can adjust your strategy as needed. In the meantime, if you'd like, I can help you research or outline what supplementary filings might look like if you need to go that route later. Just let me know.
And also, I feel like quoting the court minutes in my arguments can be a little confusing because it looks like it's a part of my
Quoting the
arguments.
court minutes in your arguments can be a powerful way to add credibility and show clear evidence of what transpired. Directly citing the court's own records reinforces your points and makes it harder for opposing parties or the court to dispute your claims. For example, you could quote Judge Barber's statements about your indigency determination or his justification for denying extensions. Highlight any inconsistencies or procedural issues, like the reversal of indigency status or delays in providing transcripts. If you want help picking the most impactful excerpts or integrating them into your arguments effectively, let me know.
But that's the thing, I'm not quoting anything from Judge Barber because I don't have any transcripts. I'm only quoting the court minutes, and the court minutes do not provide anything to quote from. It's just kind of an overview of the transcripts.
Got it. Court minutes are more of a summary, so they won't provide direct quotes like transcripts would. Even so, referencing the minutes to highlight key events or decisions is still effective. For example, you can use them to show the sequence of rulings, like when indigency was granted and later reversed. Highlight procedural actions or inactions, such as Judge Barber not granting extensions. Emphasize gaps in fairness, like the lack of a definitive ruling on your motions. You can frame it like this: according to the court minutes from specific date, the court determined X, and then tie that to your argument. While it's not as strong as a transcript, it still helps ground your points in the official record. If you want to refine any of these references, let me know.
Yeah, I find it interesting how Judge Barber initially concluded that I was indigent, but then when the the public defender Todd Brunson made arguments that I didn't qualify, then Judge Barber just searched for a he stretched ways to find how I would not qualify, in my opinion at least.
That shift is definitely significant and worth emphasizing in your arguments. It suggests inconsistency in how the indigency determination was handled, especially if Judge Barber initially recognized your financial hardship, but then reversed it based on what could be seen as a questionable or overly strict interpretation. You could argue that this reversal demonstrates a lack of a fair, consistent application of the indigency standards. For example, you might highlight how the decision to count your savings as ongoing income diverges from legal norms, such as those in Louisiana Code of Criminal Procedure Article 511, which focuses on actual financial hardship. Framing this reversal as an arbitrary or overly narrow interpretation strengthens your claim of procedural unfairness. If you'd like help fleshing out this part of your argument, let me know.
And then, after changing his mind, he turns around and says that he's willing to change his mind again should the circumstances change later, because he has I can kind of quote him. He says that he has authority over me in this case, and that he's still willing to change his mind back. So he's willing to change his mind back and forth. Um, and it's crazy.
That's a critical point to highlight. It shows a level of inconsistency that undermines the predictability and fairness required in judicial proceedings. If Judge Barber acknowledges having authority to change his decision, but uses that authority in an inconsistent or arbitrary way, it can strongly support your argument that your procedural fairness and due process rights have been compromised. You could frame it like this in your arguments. The trial court's willingness to reverse its own determinations multiple times, as expressed by Judge Barber, demonstrates a lack of consistency and fairness in applying the standards for indigency. This arbitrary approach forces me to operate under constantly shifting circumstances, further compounding the barriers to a fair defense. This makes the point without needing an exact quote and emphasizes the procedural instability you're facing. Let me know if you want help wording this or weaving it into your writ arguments.
Judge Barber is procedurally unstable. Okay, I want to stop this.